and furthest east, I believe, is Pennsylvania. So a few in between. So welcome aboard, and we will try and move this along and see if I can get everything to move the way it's supposed to move. And here we go. That's another picture of me along with my contact information. And so today we're going to spend most of our time talking about basic estate planning kinds of things. And for some of you, you've probably seen this Vine representation before. This is a tool that Everence uses to sort of categorize the kinds of things that we as an organization feel are important. And so certainly discovering and planning for your spiritual journey is an important part of this process. Living responsibly is another important piece. Preparing for the future, and then also giving generously. And when we think about estate planning, it really usually falls into the giving generously and into the preparing for the future sections of the Vine. And so that's where we'll spend most of our time today. When we think about estate planning, here's a graph, or a pie chart rather, that is a statistic that is put up by Charles Schultz. He's an attorney, not the cartoonist, and he works with estate planning in California. And his statistic says 70% of people have no plan, 20% have the wrong plan, and 10% have a good plan. And I will not ask you to verbally say which of those categories you might be in, but certainly you can probably place yourself in one of those. And it doesn't matter which one you're in today, because the good news is you're still alive, and so therefore able to make a change if you are uncomfortable with the plan that you presently have. And here are some indicators to suggest when it's maybe time to dust off that old plan and put a new one in place. When you don't have any reference in your present plan to your kids, and you now have 2 teenagers, your plan might be just a little outdated. Or if your father is named as the guardian of your kids and dad is now a resident at Memorial Home, that might also be a suggestion that the plan has a little bit of age and needs an update. And finally, if you can't remember the name of the attorney who drafted the plan, or if that attorney is now retired, no longer in business, another good signal that maybe you should take a look at your plan and update it. So let's talk a little bit about the current rules, because the rules have changed over the years. When I started doing this work about 19 years, a little over 19 years ago now, the estate tax limitation at that point was much lower, down in the hundreds of thousands of dollars. And presently, the estate tax limit is now $5.45 million for 2016, which means that if you happen to be a married couple and you own the assets correctly, you can then protect up to $10.9 million in your estate from estate taxes. So for many of us, the estate tax is not really the issue that we are most concerned about when it comes to estate planning. Back a number of years ago, that limit would have been around $600,000, and so that would catch a number of us. So again, important to know what those rules are. Now, inheritance or estate taxes by states can be different. So depending on the state that you are a resident of, it would be good for you to know what the estate tax or the inheritance tax is in your specific state. And a final bullet point there, just a note that in the political season that we're presently in, and with shrinking federal and state budgets, the estate tax rules can be changed by Congress. And so it's very possible that we'll see some changes in the future. But that shouldn't paralyze us from making changes and updating plans today, because we can update down the road if the laws change and we need to do revisions. So that's a little bit on the current rules. Let's talk about what Everence refers to as stewardship estate planning. That's a little bit different than just regular estate planning. And so if you think of this sort of in a secular sense, we'll cover all those things, but we put a little different twist on it and refer to it as stewardship estate planning. And these are the questions to ask from a stewardship standpoint. First, how much is enough for your kids? For some of us, our kids are grown and are in working situations, and they are now in careers and earning money, and may not be in a situation where they really need our financial assistance. For others of us, our children may be younger, not yet established, and so if we were to pass away sooner rather than later, it would be good to have some money available for the kids. And so the big question there, how much do you want to leave to your kids? Secondly, when is it too early or too late to leave an inheritance to your children? And there are some times when, as kids, they may not do quite as well handling money. So I'm thinking now about somebody particularly a male in 14 or 15 or 16 years of age. If they received a big chunk of cash due to your death, there might be a new car that would be in their future, and it might be bright red and go very fast. And that may not exactly be what you had in mind in leaving money for them. Number 3 there on the list, how is it best to leave a gift to charity? We'll talk a little bit about that. And finally, have I planned for incapacity? And talk more about incapacity later, but essentially it is when you're in a physical state where you're still alive but not able to think or speak or act on your own behalf. You are legally deemed to be incapacitated. So let's talk about where our things can go, because when we're talking about estate planning, it's really about distributing assets out to individuals and places. And so the 3 spots that our things can go, represented by picture here, would be family on the left, in the middle would be charity, and on the right, a shot of the 1040 income tax form representing taxes. And so if for some reason you are uncomfortable with one of those 3, you can pick 2. Or you could pick all 3, or you could pick just 1. But if we don't plan, inadvertently, we might have more money going to taxes than we might like to have going there. And so a way to offset that is to include charity in your plan as a way to reduce or minimize those tax obligations. So let's talk about now reasons to plan. And here they are. You get to decide who it is that receives what share of your assets. Secondly, you get to define and decide how and when those beneficiaries receive those inheritances. Third, you get to define and choose the executor or trustee to manage your estate. Number 4, who will serve as a guardian for minor children in the event that your children are underage. And then finally, you get to define who it is that will be a medical decision maker in case of your incapacity or incapacitation. So all of those things are important reasons to consider planning, because you're the one who gets to define and decide who serves in those roles and the timing of those things occurring. So to get started, let's talk about 4 fundamental tools for estate planning. And really these 4 tools become the foundation of all estate plans. And so if you haven't started, or if you need to start over, these are the 4 that will be important. And what I'm going to do is walk through and talk just a little bit about each one, and then at the end of these 4, we'll pause for some questions. And then after these 4, we'll sort of shift it into high gear and talk about another tool that might be attractive or that you may have heard about, called a revocable living trust that can also function in estate planning situations. So let's jump into the will and talk about advantages and disadvantages of the will. And you'll note here that we have those sort of split out by advantages and disadvantages. And this is a good spot too to just let you know that if you would like to have a copy of your slides at the end, we can either take that or you can send an email to me, and I'll be happy to send these slides to you so that you have the presentation available. So advantages for the will. On the left-hand side, wills are relatively inexpensive. So depending on the part of the country that you live in will define what those costs might be. As a general rule, it's somewhere between $400 and $600 for my folks on the West Coast in California. That number is a little bit higher. For the middle of the country, that's a pretty good number. Perhaps in the East Coast, it might be a little higher also. But when I'm talking about the $400 to $600, that includes all four of those basic tools that we're going to review here. So relatively inexpensive in the big picture of life. Wills are easily updated. Those are done with a tool called a codicil. That's a legal term that's like an amendment to the will. It is important to know and observe, sort of pay attention to the fact that the will is only effective at your death. So during your life, you're the one who's making these choices and decisions, but at your death, then the will steps in because that's your designation of where you want your things to go. And finally, on the advantage side, the will is just a simple starting point for beginning the process of estate planning. And so if your estate is fairly simplified, if you're fairly young, the will would be the right tool to use. If your estate is more complicated, and we'll talk about that with the revocable living trust, we might want to look at that as a tool for more complications. So on the disadvantage side, wills do require probate, and probate is a division of the court that oversees the proving of the will, which is what probate means in Latin, is proving of the will. The disadvantage there becomes that there are some settlement costs that are a part of that process. So there'll be some lawyer time, maybe some accountant time that gets charged for that, maybe some court costs that would occur. Probably the bigger two reasons or concerns are the last two here. And one is, for some people, they get uncomfortable with the fact that because the probate court is involved in proving of the will and making sure that what you want to have happen is carried out, then your document becomes a public document, and anyone who goes down to the courthouse and checks out your file would be able to see where all of your money went to. So that is more of a concern to some folks than others. And then finally, on the disadvantage side, it doesn't allow for the uninterrupted continuity of assets. So if you have savings accounts and checking accounts and other assets, there may be a period of time when those accounts get frozen until your executor or your personal representative can be appointed by the court, and those can be moved over, changed over to where that person has authority to act on your behalf. The will does provide a way for you to offer sensible provisions for your family and your loved ones. So you can you can dictate what it is you want to leave to them, for them in that process. It can be used to define how you wish to be buried. Can also include instructions and services for memorials. And if both of those are a part of your will, my encouragement is that someone know where your will is at and be aware of that so that they can take those into account rather than sort of having to go blindly down the road of figuring out how you want to be buried and what you would like to have done in services and memorials. The will does provide a way for you to leave money to family members. That's called a bequest or a gift at death. So it could be money, could be property, could be assets. You can do that in dollar terms, or you can do that in percentage terms, or you can do that by naming specific assets. So all of those things are possible in terms of bequests. And then finally here on this page, the final charitable gifts and explanations are available to be done through the will. So you're able to sort of describe why it is that you're leaving money to XYZ charity, and how they impacted your life and what you'd like to have them do with those dollars. The will would be a way to be able to say that. So that's the will, and again, the basic building block. It does most of the heavy lifting in the estate planning process, but one of 4 tools. And number 2 of 4 tools is a durable power of attorney. And the durable power of attorney is a written document where one person gives power to another person to act on his or her behalf. And this gets used typically when we're less comfortable or capable of making important decisions. And so now I'm thinking about if memory's not quite as good as it used to be, or if you're just not sure you trust yourself making decisions anymore. Through a durable power of attorney, you can name a family member or an individual to be able to make decisions on your behalf. Could also be a case where you're leaving the country for a period of time and you want to have someone in the country available to sign documents and handle business things for you. The durable power of attorney would be the tool to be able to use to make that happen. That is one of the features, or several of the features of the durable power. Here are a few more. Here are some of the powers that can be included in the durable power of attorney. So having access to a safe deposit box, getting money from creditors or collecting from people that owe you money, to be able to buy, sell, or lease an asset, to operate a business, to make gifts to individuals, or to make disclaimers or other estate planning adjustments to the estate plan, or the power to join the competent spouse in the signing of income and gift tax returns. So these are all powers that are available to your power of attorney to be able to do on your behalf in the event that you're not able to do that. Here are some powers that you cannot include. And so the power to execute the will, the power to revoke a will, or the power to execute a living will, or to say, here's how I wish to die. Those are all powers that are retained by you as the individual and not able to be gifted to anyone else to be able to do on your behalf. So important to recognize what your power of attorney is able to do for you. And it has a lot of flexibility, so there are some other considerations here. The durable power can be drafted in such a way that it empowers the holder to currently become the power of attorney, or to become effective only in the event that the principal becomes incompetent. So that's sometimes called a springing power of attorney, and that would likely require, then from a legal standpoint, requires some proof that you're no longer competent. And typically what I have seen is that it requires 2 physicians to be able to evaluate you and to state that your competency is in question, or that you're not capable to make business decisions, and that would then cause the power of attorney to spring forward and to become active at that point. It is important to note that the durable power of attorney does terminate at death. This might be one of the most misunderstood features of the power of attorney, is that it is only available to the holder to be able to do things for you while you are still living, because at your death, then the will is what steps up to take over, and then your executor is the person who does business kinds of things for you. Now, it's possible that you can have the same individual named as the durable power of attorney and as your executor. So there's no restriction on that being a possibility, but just the recognition that the power of attorney does cease to be active at your death. So that's number 2. Here's number 3, the living will. I just referenced it ever so briefly a moment ago. The living will is a document, a tool that's used when your death becomes imminent and irreversible. So typically that's you're 6 months away from passing due to illness, disease, some sort of condition. And the law in most states allows then for you as a person to determine whether or not life-sustaining procedures should be used to prolong your life. And the living will is the document that gets used to say, here's how I wish to be treated. So in the U.S. presently, all 50 states have adopted a similar provision since 1992. So the living will is effective across state lines. It does deal solely with life-sustaining issues. As such, then doctors become the ultimate decision makers because what you're doing is saying, well, here's how I wish to be handled and treated. I do want nutrition. I don't want nutrition. I do want water. I do want painkillers, those kinds of things. Ultimately, though, your physician is the one who, in sort of consulting with that document, will do what it is that he or she thinks is important. So the living will and the medical power of attorney, which is the 4th document, can sometimes sort of get a little mixed up. The medical power of attorney is not unlike the durable power of attorney. It's an individual who you are naming to be your representative to deal with any medical issues that you may have. And again, you're alive, you're just not able or competent to be able to think or speak on your own behalf or make decisions that are significant. So this deals exclusively with medical issues. Family members here typically are the ultimate decision makers, but having a person named as the medical power of attorney is helpful and useful. So there's an individual who can step forward and act on behalf of everyone. This document, the medical power of attorney, will generally override the living will because there may be information that's available to your medical power of attorney that's current that you would not have known or would not have been available to you at the time that you created your living will. So usually the medical power of attorney has the authority to override the living will and do things that may be different than what you initially requested. So those are the 4 basic estate planning tools. And Melissa, let's pause here for just a bit and see if there are some questions that come up before we shift into the next year and move forward with some other tools in the estate planning world.
Okay, thanks, Dennis. Yeah, I'm looking for questions right now. It's been a lot of great information, and I'll pause here for a second. Feel free to type in questions or raise your hand, and we can unmute you. Yeah, or begin to think of questions that you can ask towards the end. But I know it's been a lot of information. But feel free to let us know if you have any questions. I don't see anything at this moment, Dennis, so I'll just move along.
We'll move ahead, and it's okay. It might mean that everyone's asleep, or it might mean that I've been very clear and articulate and everybody understands. And let's go with that last one and hope that's correct.
Okay.
So let's jump into the next chapter of estate planning and talk a little bit about another tool that can be used called a revocable living trust. And the picture that I find most helpful for the revocable living trust is that of a bucket. And I can't take credit for this. I'm borrowing it from an attorney who used this in describing it to his client. I happen to be a part of that conversation, and I like the analogy so well that I've used it ever since. So with the revocable living trust, it is a legal document that you create. It's an entity that you create to own and hold assets that you own. And so the bucket really represents the documents, the structure, and the assets that you own go into the bucket. They get gifted in or moved into the bucket. And on the outside of the bucket are the instructions, which tell the trustee who will be carrying the bucket how to handle any assets that are in that bucket. And so for most of us, we serve as our own trustee as long as we are alive and competent. And at any point in the future, should you be not competent or uncomfortable making those decisions, then your successor trustee will come alongside of you and they will carry the bucket. And again, they will have to follow the rules that you have put in place that are on the side of the bucket. So advantages to the revocable living trust is that it is a document or a structure that lives beyond your death. So it avoids probate. And for many people, this becomes the main reason they want to use a revocable living trust, is to avoid that court supervision and that interruption in continuity of assets. So it also provides privacy because the trust document is not available to anyone unless you happen to share it with them, but it's not a public record anywhere. And it does provide a way for you to control. Some people refer to this as controlling from the grave, and in some cases that is what's happening. So you can put provisions in your revocable living trust that says, following my death, I want this pool of assets to be managed in this way and for it to be available to my heirs or my kids at some point in the future, or they just get access to the income for a number of years. So there's lots of control features that can be done here with the revocable living trust. Very helpful when you have children who have dependency issues or have money management issues, as a way of keeping principal together and not having it get used frivolously or more quickly than what you might want. So on the disadvantage side of the revocable living trust, it is more expensive to create because it takes more lawyer time to draft. And you have to sort of contemplate lots of different possibilities and lots of different situations and then provide for those in the written word of the revocable living trust. The other disadvantage is the transfer of asset ownership. And so if you have assets that you own individually or jointly, but you do not move them into the bucket, into the trust, then they are not controlled by the trust and therefore would still be subject to probate. And so if you miss that step or miss some assets in getting that done, sometimes that doesn't work quite as well. Good revocable living trusts and good attorneys who draft revocable living trusts will also draft a pour-over will to catch those assets. And we may talk a little bit more about that later on. But just know that there is a mechanism in place to do that, but it again adds the cost of the process. And so if you can transfer ownership earlier, that works better. I've talked about the successor trustee, the person who comes alongside of you and picks up the handle of the bucket and carries that. There really are, I have three different sort of requirements for successor trustees to be competent in. And one is that you have to be able to trust that individual implicitly, because there is no probate judge, there is no one who is sort of supervising, are they carrying out what you want them to do? So you have to have a high degree of trust in them. Number two, they either have to have the time to devote to managing your estate, managing your affairs, or be able to create that time, make that time to be able to do that. And third, they need to have some logistics available. So this should be reasonably accessible. And in today's world of email and telephone and cell phones and such, that's a different standard of logistics than what it was back a number of years ago, where physically being close made a lot more sense. So those are the three tests that I like to sort of have for a trustee, and you as the creator of that trust need to be sort of comfortable with that person serving in these ways. And if for some reason those conditions don't exist, you can and should consider a corporate trustee. So that could be the Everence Trust Company, it could be a local bank trust department, but it is an individual working for an organization who will then step in to carry the bucket and manage your affairs as you have wanted them to do. And so I actually like to see a corporate trustee named in the last position. So frequently we'll have kids named in number 1, number 2, number 3, you know, how many kids you may have or how many you are comfortable naming. And then in the 4th or the last position, name a corporate trustee, so that all of the kids, if they aren't available or don't want to serve, they can resign and know that a corporate trustee will be able to step in and take over. So that's the very quick description of a revocable living trust. I want to spend a little time on some additional estate planning tools, and then we'll have a little time for questions here towards the end. And so these are 3 of the tools I want to cover because they do have impact on estate planning and on our sort of end-of-life care. So long-term care insurance, life insurance, and the idea of sending IRAs to charity as a way to fulfill a charitable pledge or obligation. So first, let's talk about long-term care insurance. If you happen to live to age 65, there's about a 50-50 chance that you will need some sort of long-term care at some point in your life. And on average, those that need that care will need it for about 2 or 2.5 years. 1 in 5 will need care for less than 1 year. 1 in 7 will need it 5 years or more. And I'm confident that you know people who fall into these statistics that either died before needing care or have been there for 3 to 5 to 7 years due to some debilitating disease. So the need for long-term care is certainly there, and it's a tool that's available to you. And what it provides to you and to your family is assistance to pay for care either at home or in a facility. The big plus behind long-term care is that it does preserve other assets to be used by either you yourself or for distribution to family or charity. Third, it reduces the likelihood of needing to sell farmland, investment property, business assets to pay for care. And so that is a feature that's a nice feature in the plan also. So long-term care insurance is one of those tools. The disadvantage to long-term care is that it does require a premium. And so premiums are less expensive at earlier ages. But the oldest person I've written long-term care on was age 80. When she first came to see me, she said, I thought this was a really good idea 10 years ago, but my husband wouldn't allow it. And he's now passed away, and I want this. And so we were able to get her covered, and her premium was expensive because of her age. But again, it's one of the tools that's available for consideration. Life insurance is another tool that's available, and certainly in the estate planning situations available for liability management. We think of it in that sense, so it's to pay off debts and expenses that we may still have when we do pass away. Life insurance can also be an asset that's passed on to a charity. It could be used to pay real estate taxes or other estate settlement kinds of costs. I have seen it used and have helped families put it into place to provide for sort of equalizing an estate. So if there's a business or a farm that's going to be gifted or transferred to one heir, and one or two or three other heirs are not in that business, but mom and dad want to make sure that there's an asset or some passage of value onto them, life insurance can work really well for that. And if you happen to own a small business and you're in business with someone else, and they happen to pass away, then overnight you're in business with their spouse by virtue of the operation of law, which may or may not be what you want to do, may not be what they want to do. And so in an business ownership setting, if each of the owners have life insurance on each other, then the untimely death creates the cash available to buy out the share from the family that is left behind. So life insurance is a good tool that's available. I haven't added it yet, but I probably should add, there are now some life insurance policies that provide for the death benefit to be available to be used for long-term care in the event that you have not yet passed away, but you do need care. You would have an option to use the death benefit before your passing to pay for long-term care. So another relatively new feature of life insurance to help with end-of-life kinds of things. So let's go the right direction here. The third tool here is the idea of sending IRAs to charity. And I touched on this earlier. We talked about the estate tax being probably not applicable to as many folks. The real sort of kicker in estate tax and end-of-life tax kinds of issues are IRAs and other kinds of tax-deferred assets that where the tax was not due at the front end, but is due to the heir when it's passed on. And so to the extent that you have a portion of your estate going to charity, if there's a way to line up an IRA or a tax-deferred asset to fulfill that obligation to charity, that is a more tax-efficient way to do that, because when a tax-deferred asset is passed to charity at death, there is no income tax that's due or payable. And so it preserves more of the estate to go to family members or other charities. So in the event that you can sort of organize things that way, it is a good tool to be able to do that. Where to begin? After a session like this, it's easy to feel sort of overwhelmed with, oh my goodness, all this stuff, but I just don't know where to start. And so here are three things that I offer to you as ways to sort of get things moving. And first on the list is preparing an asset summary. And sometimes that's called a balance sheet. Sometimes that's called a net worth statement. Sometimes it's just a piece of paper that says, here are the assets that I own, and approximate values that you think they might be worth. Two, defining your wishes for distribution. This probably is the toughest piece, because sort of figuring out how much is enough to kids and then where you want things to go, that's tough work. And sometimes that sort of stymies the process, and folks get stalled and not able to move forward. And then third, to coordinate your estate plan with a team of people. So someone like myself as a financial planner, your tax professional, a qualified attorney, having the team assembled to be able to do the work is a good thing. Because I don't hold myself out to be a tax professional. I'm certainly not an attorney. I don't draft documents. Likewise, your tax professional might not understand how some of the investments and other kinds of things are handled and flow. And so having the whole team assembled is a good place to begin with this process. And I'd resist the urge here to procrastinate, because mortality is still 100%. We all will die, barring the second coming of Christ. We all will die. So having a plan in place is a good thing to have before we need it. And so resist that urge to procrastinate and move forward in that. And that really brings us back to the vine and sort of again, that stewardship focus to estate planning, recognizing that this is just one part of the total process of your wellness journey, your stewardship journey, is having the estate plan put in place. Here's a slide that has a lot of disclosure stuff that the people that regulate the work that I do think is important for you to be aware of. And so there's that. Here's my contact information, and I'm going to leave this up for a while here so that you can see that. And really, while we answer questions, I'll leave it up. These are phone numbers and email addresses for how to reach me. I do live in Colorado. I travel to see clients in various locations, but I find that most of the work that we need to do can be handled by telephone and email. And so happy to respond to specific questions that you may have about your situation. And if you happen to have an Everence advisor in your locale, in your area, they also are a good place to go. And some of them are very competent and comfortable with these kinds of questions. Others will know how to get a hold of someone like myself to be able to get a little farther. So Melissa, let's open it for questions and see if any have come along, and if not, that's okay too.
All right. Well, thank you, Dennis. That was very informative. It was a lot of great information. Yeah, thanks for those of you that that took time out this afternoon. I don't see any questions pop up right now. So we won't keep you very long this afternoon, but yeah. Any last words, Dennis, while we're waiting for questions? I'll wrap this up fairly quickly if we don't have any questions.
Sure. Well,
So,
one of the questions that does frequently come is how often should an estate plan be reviewed? And it's one of those questions that is different for everybody in every situation. My general encouragement is to pull your plan out every 3 to 5 years and read through it. And if the people that you have named and the plan that you put in place still sounds okay to you, then it's probably okay. However, if you've had a life event that has occurred, so now I'm thinking about divorce, marriage, birth of a child, death of a child, death of a spouse, those are life events that can have an impact on sort of how the plan works and how it flows. And those are also good times to be able to review the plan just to make sure that it's doing what you want it to do. And again, financial advisor, accountant, attorney, all good people to sort of consult with about these things. There have not been huge and significant changes to the tax code that's really made it important to make significant changes in the last number of years. But if your plan is 10 or 15 years old, it would be a good idea to do a review.
okay, that was very helpful. Well, I have still not seen any questions, but you can always feel free to email Dennis, and you have his email right there in front of you, so feel free to ask questions that way. Well, thank you so much for joining us this afternoon for this webinar on estate planning. It was very informative, and we're glad for you to join us. Thank you, Dennis, for presenting. And
yes, and thanks who signed in.
Yeah, and thank you all for attending. Everyone have a great afternoon. I'll be ending the webinar now. Okay, thank you very much.